Please note that the information referenced in this video is accurate as of April 5th, 2024. Changes to laws and regulations may make portions of this segment outdated and no longer relevant. Information presented is for educational purposes only and is not intended to provide investment, tax, or legal advice. Please see our full disclosure at the end of this video.
Welcome to Retire Vivid. I'm McCarty, that's Tommy Breitbach, and today is about getting you that voice when it comes to estate planning. And that's why we have a special guest in studio today, Matt Bollman. Matt, thanks for joining us.
Thanks for having me, Cam.
So Matt, before we dive into all of this, we're going to talk about estate planning. I also want to touch on wills versus trusts. We're going to talk about asset protection from long-term care costs. Tell us a little bit about you. Your practice, your law firm, and then we'll dive in.
So I work at Pearson Bollman Law, pretty narrowly focused law firm. So we do estate planning, so that's wills, trusts, power of attorney documents. We do probate trust administration, so that's advising the executor or the administrator through the probate process. We also advise successor trustees through the trust administration process. We also have kind of this niche area that we call elder law, focuses usually on asset protection against long-term care costs. We do special needs trusts, and then we do litigation related to all those areas. We've got an office here in West Des Moines, over in Bettendorf, Dubuque, Cedar Rapids, also up in Okoboji.
And that's why we're excited for you to be here, because a lot of times we see, an estate plan being a really important part of your financial assets. We run into people that, may have a tax advisor meet with them once a year, get their taxes prepared, meet with their financial advisor once, twice a year, and then, meet with an estate planning attorney as needed, get that document in place. And so where we see, that disconnect being is not putting all those pieces together in one room and making sure everything's working the way you want it to.
Yeah, and that's what's great about having all of us at this table here. So let's dive in, Matt. So what I want to do first, I want to talk, before we get into wills versus trusts, let's talk about the basic documents. And so let's talk about the power of attorneys. Let's start there.
Yeah, so whether you're doing a will-based estate plan, whether you're doing a trust-based estate plan, you also have to have some of these other foundational documents. So, making sure that you have a financial power of attorney, making sure that you have a healthcare power of attorney, making sure that you have a living will.
Perfect. And so with a power of attorney, let's stay on that for a second, because so many times what we see, clients will come in and they'll say, Cam, I'm just going to put my son Jerry on the account, for example,
Yep.
you say don't do that.
Yeah. So the financial power of attorney is you're still alive, unable to make financial decisions. Who's going to be your substitute financial decision maker? You know, again, we oftentimes have that situation where they want to kind of do an end around and they want to put their son on as a joint owner or their daughter on as a joint owner. You know, we advise clients not to do that. Let's just make sure that we've got the financial power of attorney. The issues that you run into with the joint ownership are, you know, what if that son or daughter then gets into a car accident,
right,
potentially losing that asset to creditors? Or what if that person predeceases you? Then you have nobody to act in that role. Your loved ones potentially would be forced to put in place a guardianship conservatorship. So make sure that you've got this financial power of attorney document in place.
And that could also be a divorce.
Absolutely.
I mean, all of that can, that's a lot of reasons of why you shouldn't do it.
Yeah, potentially
right?
losing that asset to, you know, your ex-daughter-in-law or son-in-law. Correct.
So it's best not to do it. Staying in that same vein, healthcare power of attorney, kind of a similar document to financial power of attorney.
Yep. Unable to make healthcare decisions, who's going to be your substitute healthcare decision maker? You know, if you haven't had this updated in maybe, 12, 15 years, probably a good idea to update it. Potentially you're missing the HIPAA medical release information form.
Now, and also, Matt, a lot of times with these healthcare power of attorneys, they include a living will in one document, right?
The living will, I describe it as, if death is imminent, do you want life-sustaining procedures performed on you? Oftentimes the living will and the healthcare power of attorney are on the same form. Kind of something to make sure that you do on this is, once you execute those documents, make sure you take them into the hospital or clinic, have them scanned so that they have it on file. Make sure that your agent has a copy of it, your healthcare agent, so that, it can be utilized in that crisis situation.
Matt, these seem so simple. But with your experience, how many people, are in terms of people that have these foundational documents, do you run to a lot of people that don't?
Yeah, we do a lot of estate planning, so we review a lot of estate plans. It's surprising to me how many people have visited with an attorney for whatever reason they're missing one of these documents. So just double check that you have them in place. If you haven't had these updated in, 5, 10 years, it's probably a good idea to make sure that you've got the right person, that you've got updated documents.
And just a reminder, these are, regardless of, the estate plan you choose, you should still look at the financial power of attorney, healthcare power of attorney, and living will, regardless of any route.
Whether you have a will or whether you have a trust, you will always have these financial power of attorney, healthcare power of attorney, living will documents as the foundational set of documents.
Okay, so again, guys, that's why we talk about the foundational documents, but next is the big one. We're going to talk about wills versus trusts, the pros and cons of each. Which one should you pick? Stay with us right after the break.
Do you have questions about your retirement plan, or do you want to know if you are on the right track? We are here to help. Simply go to retirevivid.com or call the number below to schedule a 15-minute retirement review. You can speak with us about taxes, Social Security, your 401k, or any quick retirement questions at no cost to you. We are here to make retirement vivid. Schedule your 15-minute retirement review today.
Welcome back. If you just joined us, you caught us at a pretty good part right now. We're going to be talking about will-based estate plans, trust-based estate plans. I'm pretty excited to go through this.
Right. The question is, which one do you need? Very briefly, Matt, you have kind of two main differences between the two.
Yeah, both plans generally are designed to do the same things. They're designed to distribute your assets to who you want, when you want, how you want. But two significant differences, the first one is, when do the plans become effective? A will-based estate plan does not become effective until after you pass away. Whoever you've listed as the executor will go hire an attorney. The attorney will do the opening probate paperwork. They'll file that with the court. That's when the will becomes effective. Whereas a trust becomes effective just as soon as you sign it. It creates a new legal entity, an entity that can own assets, an entity that can exist after you pass away. So when they're effective is one big difference. The other one is how they're administered. So if you have a will-based estate plan, that is going to be administered through the probate process. Probate is that court-supervised system of distributing assets, where just generally trust-based estate planning is designed to avoid that probate process handled through trust administration.
And Matt, I mean, there's not one plan that fits all. I mean, a will fits certain people. A trust may fit certain people as well too. So before we get into the trust, let's talk about a will-based estate plan.
Again, remembering will-based estate plan equals probate. Some of the reasons that people don't like the probate process is it seems to take too long, seems to cost too much, and it's public information.
Sure, and so that leads into also, which I like to bring up with a will, is the no privacy aspect of it.
Probate, all the paperwork's being prepared by the attorney, submitted to the court. Everything that runs through the courthouse is public information. Anybody can go down there, they can take a look at your will, they can take a look at your inventory, they know what you had, they know who it's going to go to. Some people don't want that public information aspect of it.
In working through the courts, that that may extend a time frame and can get expensive.
Yeah, I mean, it sometimes is a lengthy process, with working with the law firm, the executors working with the law firm, having to prepare the paperwork, obviously submit it to the court.
So let's just really dive in here in terms of probate.
Yep.
Because obviously that we're going to get into trust-based estate plans here in a minute. But Matt, let's just take $1 million estate and let's just kind of walk through what that looks like.
Yeah, so I mean the costs are statutorily defined. So the statutory maximum an attorney can charge is 2% of the gross estate value. The executor can charge 2% of the gross estate value. And then court costs has recently changed 3-4 years ago. It's 0.2% of just the probate value. So if you're talking about $1 million estate and all the assets are going through probate, that's potentially $20,000 in executor's fees and attorney's fees and about $2,000 in court costs.
So as you start getting up there in the estate value, those costs can add up quickly. So for those, maybe looking at the will-based estate plan, who should have a will?
Yeah, I mean, people that are looking for a more simplified plan for themselves, maybe people who are less organized, where a trust, in order to have a trust-based estate plan, you have to be a pretty organized individual. So, if you're not, let's stick with a will-based estate plan. And then you have to do kind of just the math on it. Does it make financial sense to invest extra money setting up a trust instead of the will to avoid that probate process?
Now, okay, so that's will-based estate plan. Why don't we move forward, Matt, and let's talk about a trust-based estate plan. So let's dive into that in terms of what people are looking for with those plans.
Yeah, I mean, I look at trust-based estate planning as that client trying to organize things today to make it easier and less expensive to administer at the point you pass away. So avoiding that probate process is a piece of that.
And avoiding that probate process keeps it out of the court.
Absolutely, correct. So it's handled through trust administration. It's handled in a more private family setting. All the paperwork isn't flowing through the courthouse.
Yeah, right. So that's that privacy end of it, correct? Now, what about time? I mean, is it about the same time in terms of closing an estate, or is it more?
I mean, I would look at it as, there's certainly, you're avoiding all of the court system process. So usually they are open and close faster. It's usually more heavily managed by the trustee, maybe relying a little bit less on the CPA and the state attorney.
Mm-hmm. Got it. And then going back to the probate costs, right? You were talking about executor fees, attorney costs, court costs, that sort of thing. Can you kind of just walk through what you may potentially eliminate with a trust? I mean,
generally, it's the trustee hiring somebody to advise them. So they're hiring an attorney, they're hiring a CPA. Just generally, the attorney's fees are either charged on a reduced gross estate value, or they're done on an hourly fee basis. The trustee fees, if it's an individual, normally hourly or reduced gross percentage of the gross estate value. And then you're avoiding all of the court costs.
So Matt, you talked about a little bit of the privacy end related to trust and potential cost savings versus probate. Who then would be looking at a trust-based estate plan?
Those individuals that again they want to organize things today, make it easier and less expensive to administer at the point that you pass away. But you need to be highly organized. You need to make sure that the trust is fully funded, but really looking to avoid that probate process.
I think one of the biggest things that we've seen, Matt, is people say if they have a trust, they just don't fund it. And I don't know if you bumped into that with your law firm.
Yeah, I mean, and it's a big part of the education process when people set up trusts is that, the key takeaway is that at the point you pass away, you need to make sure that all of your assets have a plan, meaning they're titled in the trust, have a beneficiary payable on death, transfer on death, that every asset has some mechanism to go somewhere so that all of the assets avoid probate.
And that's a really great point. We've bumped into, it's typically a client that is going through something with their parent that may not have been highly organized. And that brings them to saying, I don't want my kids to go through that same process.
Yeah, no, I mean, we definitely find a lot of clients who've been through the probate process, and when they experience that, they're looking to then do trust-based estate planning.
Right. And so, in particular, you're mainly talking about, that's just trust in general, but because there's different types of trusts. Obviously revocable trust, irrevocable trust, but you're also a fan of contingency trust. Let's talk about that.
Whether you're doing a will-based estate plan, whether you're doing a trust-based estate plan, we're a big believer in making sure that you have these backup beneficiary protection plans. You just do not know what your beneficiaries will look like at the point you pass away. So that's, setting up an underage trust in your document. So this is, your child predeceases you, assets are now going to grandchildren. Let's make sure that we've got an underage trust built in. Or somebody doesn't have capacity, drug, alcohol, otherwise doesn't have capacity. Or if somebody became disabled receiving means-tested government aid, let's make sure that we've got a supplemental needs trust so that we don't bump them off that government aid with an outright distribution. So, we put those in all of our wills, all of our trust documents.
And Matt, let's address a few concerns related to, estate planning. Can you quickly detail the difference between a revocable trust and an irrevocable trust?
Yeah, usually the primary driver that somebody does a revocable trust is to, again, organize those things today to make it easier and less expensive, avoid probate. The irrevocable trust, that's when we get into asset protection against long-term care costs.
And within revocable versus irrevocable, there's a control issue.
With an irrevocable trust, that grantor, that person creating the trust, they're not the trustee, they're not a beneficiary. That's what creates that asset protection against long-term care costs.
And so we'll talk about that here in just a minute, but let's stay on some other concerns, especially with your IRA, your 401k money. Let's talk about that, Matt.
Sometimes your largest asset today, that's always going to be controlled by the beneficiary designation form. So, are you using a named beneficiary? Are you sure that that person's going to make the right decision as far as making a claim on that money? Do you want to name a trust instead so that you've got somebody else making that decision making? We also run into the situation of, are you concerned about if you predecease and your spouse remarries? Are you worried about them disinheriting the kids? And then lastly, we obviously do a lot of business farm succession planning. That typical farming situation is one of the kids stay back to farm, two of them moved off the farm. We're land rich, cash poor. How do we treat everybody fairly in that situation? We've got enough experience to work through those situations.
Staying back on, if it is a second marriage or whatever, and you are worried about the kids. You do have a story on this, don't you?
Yeah, there was this couple out of Cedar Rapids. I think he was 88 and she was 86, and that she was just convinced that if she passed away first, he was going to marry the woman down the street and disinherit the kids.
So the point is estate planning can help solve some of these issues, correct?
Absolutely. Let's make sure that you document all of your concerns so that when you go into the estate planning law office, at the point that you leave, you got all your concerns addressed, and that you've got some peace of mind that things are going to work out the way you want.
We talked about a lot today, and of course, a lot of you may have questions about your own retirement or maybe estate planning in general, and that is why we offer a 15-minute retirement review where you can ask us questions about this topic, whether it's about wills, trusts. We can speak with Matt, or if you want to talk about retirement planning in general, we encourage you all to take advantage of that. Again, it's a 15-minute retirement review. Next, we're going to be addressing asset protection from long-term care costs. Make sure you stay with us right after the break.
Retirement planning can come with more questions than answers. How do I save money in taxes during retirement? When should I file for Social Security? And how do I retire my 401k? With so much to plan for, how do you know if you are making the right decisions? We are here to help. Join our upcoming retirement class by going to retirevivid.com, where you can choose the setting. Whether you want to be at home listening online or if you want to see us at an event, it's up to you. We are here to help you get retirement ready. Redefine your retirement journey today.
I'm Cameron McCarty, talk show host, financial advisor, and business owner.
Did you know Cameron is happily married, raising 4 kids, thinks he's a news anchor?
I don't know about that one.
But did you also know he helps people get retirement ready? He can help you too.
That's why I'm coming to you on the weekends, getting you answers to your retirement questions.
Don't miss him on Retire Vivid, every weekend on ABC.
Welcome back. If you just joined us, you missed a lot. I mean, we talked about a lot of information today. So we're going to now shift gears. I want to get into asset protection from long-term care costs. Matt, this is also something that can be a tough conversation. I mean, to think about this stuff, but it's something we got to talk about.
This kind of falls under our elder law practice area. This is where we're talking to clients about oftentimes qualifying for Medicaid. Medicaid has 2 broad-based programs, the elderly waiver program that can bring home care into the home, potentially also covers assisted living, and then facility Medicaid, which covers the nursing home.
This topic is becoming, more common, and it can be very expensive.
Statistically, somebody's going to need some type of home care, assisted living, nursing home care.
If there's anything, Matt, that's keeping up with inflation, it's this. I mean, it is pricey. And so this is the things that I think people get, that in terms of a fear that they have is it could just cripple an estate, And so, what are your options in terms of paying for care?
One is, if you've made the choice and had the opportunity and have the means, purchasing long-term care insurance, always potentially an option. It's insurance. It's covering the risks that you're trying to cover. Otherwise, you're privately paying. But in the metro area, the cost of care is $10,000, $11,000 a month in the nursing home. Qualifying for Medicaid, qualifying for a VA pension.
So for those who are looking to qualify for Medicaid, there is a Medicaid transfer rule that they need to be aware of.
Yeah, the big rule with Medicaid is that there's a 5-year look-back period on the transfer of assets. So, on that Medicaid application, we'll ask you, have you made any gifts within the prior 5 years? If so, was it for less than fair market value? Were those assets gifted away? There are some major exceptions to that rule, though. You can make unlimited transfers to a disabled child. You can make transfers of your home to a child who's been providing care in your home for the prior 2 years, and but for that care, you would have needed institutionalized care. You can also make unlimited transfers between spouses. We often have clients come in with some preconceived notion that, they move their husband to the care facility, that they have to spend his assets down. That's not correct. You can literally transfer all the assets to the spouse still at home and then get below the asset numbers. And then the DHS policy manual has a whole list of exempt assets. Let's make purchases of those exempt assets and make those assets non-countable.
Yeah, that's why you work with a professional. If there's any good that we're giving today, is just understanding what your options are, because again, this is what you do. This is what you do. But Matt, there are ways where, for example, somebody may come in and say, Cam, you know what, my parents, or they've had it usually triggers somebody to do something in terms of looking at long-term care insurance or doing what we're about to talk about. They've experienced it firsthand, right? Maybe a family member or whoever it may be. But there are ways that you can be proactive. Let's talk about that in terms of staying within the realm of trust-based estate plans.
When we have clients come in and they've got this concern about asset protection against long-term care costs, that's when we're potentially advising them, or at least considering, potentially setting up an irrevocable trust. An irrevocable trust has many more benefits over just direct transfers of assets. Oftentimes clients are just maybe moving their house, maybe moving their acreage or small farm to the irrevocable trust, so that it's starting that 5-year look-back period on the transfer of assets, so that if and when they ever need to qualify for Medicaid at a later date, that asset that's been in this irrevocable trust for 5 years or longer would never be countable on a Medicaid application, never coverable under state recovery.
And that's an important distinction, is that there can be a portion put into an irrevocable trust, and some kept for your benefit.
That's a good point.
Yeah, I mean, we would never advise a client to move all of their assets to an irrevocable trust. It's just the assets that they plan on not spending, the assets that would stay out. We would certainly advise them, let's make sure it has payable on death, transfer on death, beneficiary designation, so that all of the assets still avoid probate. So we're trying to accomplish two different goals there.
Also, one of the things too that to keep in mind, because you also work with farmers, right? I mean, you want to keep that stepped up in basis, especially when it comes to farm ground. That in this type of trust still accomplishes that, correct?
Yeah, good point, Cam. Again, one of the big benefits over just directly gifting assets to children is this type of irrevocable trust still retains that cost basis adjustment, meaning the kids at the point mom and dad have passed away will receive the date of death valuation of that asset versus what they originally purchased it for, potentially eliminating a lot of capital gains taxes.
And Matt, the irrevocable trust is for those individuals who may have a concern or looking at the pre-planning. There are also options if you're in a crisis situation.
Yeah. So I talk to clients kind of from two different perspectives with this elder law Medicaid planning situation. What we've been talking about is that proactive perspective where we're trying to get the 5-year look-back period started on the transfer of assets. We also work with a lot of clients who are in this crisis scenario where they've moved their husband or wife to the care facility, they got their first bill for $10,000. What do we do in that situation? There's all kinds of techniques that can be utilized to reorganize income and assets and really preserve all those assets for the spouse still at home.
Guys, this is a lot of great information. I mean, we covered a lot. So for a lot of people here, you still may have questions in terms of about your own plan or this topic alone when it comes to estate planning. And Tommy, that's why we do that 15-minute retirement review.
Yeah, we have for maybe the simpler or the quick questions, we have that 15-minute call option. We also offer in-person and webinar classes on specific topics related to estate planning as well as others. That's
exactly right, Tommy. I mean, we covered a lot of great information today. Matt, I can't thank you enough for being here today.
Yeah, thanks for having me.
Our goal is to help you, guide you, give you the tools that you need to make an informed decision during your own retirement journey. And again, please like us on Facebook, especially if you want to stay up to date with everything Vivid. We are on every weekend helping you get retirement ready. We'll catch you next time right here on Retire Vivid.
Do you have questions about your retirement plan, or do you want to know if you are on the right track? We are here to help. Simply go to retirevivid.com or call the number below to schedule a 15-minute retirement review. You can speak with us about taxes, Social Security, your 401k, or any quick retirement questions at no cost to you. We are here to make retirement vivid. Schedule your 15-minute retirement review today.
Cameron McCarty and Tommy Breitbach are investment advisor representatives of Vivid Wealth Management, a SEC-registered investment advisor located in Des Moines, Iowa. Matthew Bollman is a licensed attorney with Pearson Bollman Law. Pearson Bollman Law is not affiliated with Vivid Tax Center, Vivid Wealth Management, and Vivid Tax and Wealth Advisors. The information presented is not provided in the course of an attorney-client relationship and is not intended to constitute legal advice or to substitute obtaining legal advice from an attorney licensed in the appropriate jurisdiction. Investment advisory services are offered through Vivid Wealth Management, LLC. Insurance products and services are offered through Vivid Tax and Wealth Advisors, and individually licensed and appointed agents. Tax planning and preparation services are offered through Vivid Tax Center, LLC. The preceding entities are affiliated. Information presented is for educational purposes only and does not intend to make an offer or solicitation for the sale or purchase of any specific securities, investments, or investment strategies. Case studies and examples presented are hypothetical and used to demonstrate a concept. These studies do not represent actual clients or results. Similar or even positive results cannot be guaranteed guaranteed. None of the entities above are affiliated or endorsed by the Social Security Administration or any government agency. Information expressed does not take into account your specific situation or objectives and is not intended to provide investment, tax, or legal advice. Listeners are encouraged to seek advice from a qualified tax, legal, or investment advisor to determine whether any information presented may be suitable for their specific situation. Past performance is not indicative of future performance. Investments involve risk and, unless otherwise stated, are not guaranteed.
Thanks for watching Retire Vivid. Want to see more? Like and subscribe to our channel to stay up to date with exclusive Vivid content. Plus, be sure to watch our show Retire Vivid every weekend. We're here to help you get retirement ready.